stop. The High Court has held, inter alia, that bracket 1, all appointments made in the selection processes involved were violative of Articles 14 and 16 of the Constitution, and therefore null and void. As a consequence, of the judgment of the High Court, approximately 25,000 appointments. Do we have the exact figure?
25,735. 25,735.
All. All right. Approximately 25,000 appointments would stand to be abrogated, 25,000 appointments would stand to be set aside. Let's stop. During the course of the cases before the High Court, there was a direction to the Central Bureau of Investigation to conduct an investigation in regard to the alleged illegalities, in regard to the alleged acts of criminal wrongdoing arising from the selection process. When the matter traveled to this court, the order dated 9th November 2023 directed the CBI to complete its investigation within 2 months and to submit a report to the High Court. In the meantime, this court directed that the appointments which were granted during the pendency, that the appointments which had been made shall stand protected for a period of 6 months to enable the division bench to adjudicate upon the matter. Next. In the earlier order dated 9th November 2023, this court was of the view that the direction of the High Court for the termination of the services of candidates at the interim stage, even before the final disposal of the petitions, ought to have been avoided Let's stop. before the High Court, as indeed before this court in the earlier proceedings, a fundamental issue which arose for consideration was in regard to the admissibility of the OMR sheet images which had been recovered by the CBI full stop. The court noted that the investigation by the CBI was yet to be completed full stop. The admissibility of the OMR sheet images being in question, this court observed that the question of the exercise of power in relation to the discovery of electronically stored OMR sheets implicated serious allegations in regard to the manipulation of records, having regard to the number of persons who are likely to be affected by the outcome of the proceedings, it was considered appropriate to remand the proceedings back to the High Court for a final decision on the writ petitions. Before dwelling further on the ultimate directions which have been issued by the High Court, it would be necessary to note at this stage that to make a brief reference to the report dated 5 February 2024, which was the last report, which was the final report which was filed before the High Court. The report of the CBI notes that the West Bengal School Service Commission, into brackets WB-SSC, SSC, had awarded a work order to a company by the name of NISA, NYSA Communication Private Limited, for scanning and evaluation of the OMR sheets pertaining to the selection tests for each of the 4 categories the scanning of OMR sheets was undertaken by the aforesaid company at the office of the SSC. It further emerged during the investigation that the company which was awarded the contract by the SSC had further assigned the work of scanning the original OMRs to an entity by the name of Data Can Tech SC.